So if you're at a bar and somebody slips something in your drink, like a Mickey, and you end up getting arrested for DWI, is that a way to get the case dismissed? Unfortunately, in Texas, the answer is no. There's no defense to DWI known as involuntary intoxication because the prosecutor doesn't have to prove that you intended to commit the crime. It's different for like a bank robbery where they have to prove that you bought the gun, bought the ski mask, Googled where the nearest bank was, that you went in with guns blazing, things like that. DWI is a strict liability crime in Texas, which means if you're over the limit, regardless of how that alcohol got into you, whether it was by peer pressure, by hazing, by undue influence, or even if they forced you to drink it somehow, that's not a defense to DWI in Texas in court. Now, as an experienced defense attorney, if that happened to my client and I'm able to prove it with a blood test or I'm able to prove it with video surveillance, that would be something a prosecutor should take into account as a mitigating factor. But that in and of itself is not a defense to DWI.